Court calls case People versus Tariq Day.
Nimish Ganatra, Senior Assistant Prosecuting Attorney for the People.
Hello, Tariq Samar, Tariq Day here.
Already, Judge. Court Feaster, Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
That reaction isn't surprising at all. It usually comes from spending hours scrolling through online videos and convincing yourself you've mastered the law overnight. After watching a few confident voices on a screen, people start believing they know better than the licensed attorney standing beside them. That false confidence can feel empowering, right up until reality steps in. Many assume short clips and simplified explanations can replace years of training and real courtroom experience. But once proceedings begin, the gap between internet knowledge and legal expertise becomes painfully obvious. The courtroom has no patience for guesswork or half-understood rules. Situations like this highlight exactly why professional legal guidance exists in the first place. Trained attorneys understand procedure, timing, and consequences that videos never explain. Trusting real expertise doesn't just protect your case. It often prevents small mistakes from turning into serious problems.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
You're being given a clear choice. Arrive on time at 3 o'clock, or prepare to spend your weekend facing the fallout. This is not the kind of warning that gets repeated or softened later. The judge in charge, Judge Simpson, is known for expecting strict compliance with his directions. When he sets a requirement, he expects it to be followed exactly as stated. Ignoring his instructions is not treated lightly, and hesitation often leads to swift consequences. Many people make the mistake of assuming they can push boundaries in court, only to realize too late that the rules are firm and unforgiving. The courtroom operates on structure, deadlines, and respect for authority that in moments like these, the safest and smartest move is simple cooperation. Showing up as instructed avoids escalation and keeps matters from becoming more serious than necessary. Following the rules isn't just recommended here. It's the easiest way to stay out of further trouble.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line. Why don't we do this? give me about 3 minutes. I'm gonna take a recess, then I'm gonna come back, because everything's going downhill, and it's those two guys' fault.
So now the approach is to redefine legal terms on the spot and hope they suddenly mean something else? That's simply not how the legal system operates. Words in law carry specific meanings, and altering them doesn't change their authority or make an argument legitimate. Courts rely on established definitions, not personal interpretations created in the moment. This serves as an important reminder for anyone paying attention. Picking up scattered ideas without fully understanding them can quickly lead to confusion and misplaced confidence. What sounds convincing online often falls apart the moment it's tested in a real legal setting. When people continue following misleading explanations without proper direction, situations can spiral faster than expected. Small misunderstandings turn into major problems when no one steps in to correct them. That's why unchecked information can be so dangerous. The smarter path is always to rely on credible sources and verified knowledge. Consulting professionals who actually understand the law helps avoid unnecessary mistakes. In legal matters, clarity and accuracy matter far more than confidence built on shaky information.
Tariq Samar Tariq Ade, the executive of the Tariq Samar Tariq Ade Living Trust. Owner Tariq Ade, Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter.
Yes,
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding,
Fleeing and eluding third degree.
third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay,
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
Well, as soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct, I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party Wall Street Towing and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department.
It's always striking how some individuals sincerely believe they can bring an entire courtroom to a halt simply by assigning made-up legal titles to a judge or court official. Declaring someone a fiduciary or a beneficiary of a trust they personally imagined may sound clever, but it has no grounding in reality. The core issue is simple. The trust being referenced does not exist in any legally recognized form, and even if it did, that approach would still have no power inside a courtroom. The legal system does not operate on personal declarations or invented frameworks. It never has, it doesn't today, and there's no indication it ever will. Courts rely on statutes, precedent, and established procedure, not creative reinterpretations. What actually happens is predictable. When people attempt to substitute real law with imaginary rules, the process only becomes more complicated for them. Confusion replaces clarity, and frustration replaces progress. In the end, the system keeps moving forward, while the person making the claim is left dealing with unnecessary consequences of their own making.
Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Yeah. Finish?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
There's an honest question that needs to be asked here. Have these documents, or this same method used by others, ever actually produced a successful outcome in court? If the answer is no, that alone should be a serious signal. A strategy without a track record isn't a strategy at all. It's just repetition without results. Continuing to rely on something that has never worked only delays progress and increases risk. Courts measure outcomes, not intentions, and unsupported approaches consistently fall apart when tested. Experience has shown time and again that results come from preparation, knowledge, and adherence to real legal standards. Eventually, the pattern becomes impossible to ignore. Proper legal guidance offers structure, accountability, and proven methods that actually move a case forward. When the goal is a real resolution, choosing what works rather than what sounds convincing is always the wiser decision.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point.
If I were in your position, I would treat that warning with the seriousness it deserves. Anyone familiar with Judge Simpson's courtroom understands that what you're seeing now is his restrained approach. This is the measured version, not the point where consequences begin to escalate. Ignoring that reality has led many people into situations they didn't expect. When cooperation breaks down, the judge has a well-known response. Uncooperative adults are often given time in the Washington County Jail, not as a spectacle, but as an opportunity to reflect on their decisions. That step isn't taken lightly, but it is taken decisively when patience runs out. The officer position between you and the exit isn't there by accident. Their role is to maintain order and ensure the courtroom operates without disruption. That presence alone signals how seriously the situation is being handled. History shows that testing the limits of a judge's patience rarely ends well. The court operates on structure, respect, and compliance. Following instructions and respecting the process isn't just polite. It's the smartest way to avoid consequences in a place where every choice carries real weight. School.
They will be here, if not by the end of the day in the drop-off box, and you'll have more tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not.
Don't need to.
They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery,
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning.
Let's break this down step by step. The court does indeed have personal jurisdiction over you, and the reason is straightforward. You have appeared before it. If jurisdiction didn't exist, your presence would be irrelevant, and any attempts at intimidation or pressure would carry no weight. The court's authority only matters when someone is actually under its reach, which is why showing up and engaging properly is so critical. That a similar misunderstanding happens with certain self-styled sovereign citizen groups. They sometimes hold informal meetings in parking lots, attempting to bring charges against elected officials. And yes, this really occurs, but the comparison is almost comical. It's like a student council in high school trying to discipline the principal, except the organizers never even followed the proper rules themselves. The officials they target never participate because these gatherings have no real authority. The key takeaway is simple: without personal jurisdiction, the court cannot act. That's why attending when required and following the established legal process isn't optional. It's essential. Engaging properly ensures the system functions as intended, and it prevents individuals from creating chaos for themselves by misunderstanding how the law actually works.
I will ask you again. Do you wish to have discovery provided to you?
Yes.
Do we have copies of discovery available that can be provided to this defendant?
Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. So are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All right.
Documents.
All right. Those need to be gotten to the defendant. How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him.
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it share?
I do, Your Honor.
Okay.
1410.
Okay, gotcha. All right, you'll make sure that that is sent to him.
I will.
You also have an email address so that all things can be emailed to him also.
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened duress or coercion of you, saying that you would help put out a bench warrant for my arrest.
Once again, the reasoning here just doesn't hold up. Article 1, Section 10, Clause 2 of the Constitution addresses excessive taxes on imports and exports, not routine traffic stops. The issue at hand isn't about tariffs or commerce. It's about a traffic violation. Your boat was impounded because you chose to flee from law enforcement during a stop, a decision completely unrelated to that section of the law. Attempting to link this situation to that constitutional clause is irrelevant and only serves to weaken your argument. Understanding which laws actually govern a scenario is essential. Misapplying provisions from unrelated areas of law will always lead to failure. In cases like this, the safest and most effective path is to focus on the rules that truly apply. Following proper procedures, respecting the process, and addressing the actual legal issues at hand is what ensures a case can be handled appropriately, without unnecessary complications or wasted effort.
The subject matter in regards to the name as well as the vessel that was used is again under, it was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly functioning at this time.
Naturally, they are going to show up because deep down, even they know their argument doesn't hold much weight. This isn't some imaginary trust court or fictional corporate tribunal. This is a real court date, with real rules and real consequences. Failing to appear would only put them in serious legal jeopardy, because the court has both personal and subject matter jurisdiction over them and their case. That brings us to the end of this breakdown. We'll be watching closely when this individual returns to court on April 25th, and it will be interesting to see how things unfold. In situations like these, making up new terms or relying on fiction doesn't work. The facts and the law always win. If you found this video helpful or eye-opening, give it a like. If not, a dislike is fair. But leave a comment and share your thoughts. And don't forget to subscribe with notifications turned on so you never miss new updates and courtroom analyses.
With that,
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
in person.
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple councils extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable.
setting the date
So,
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PC, to a preliminary examination.
just for the record, I put it on the record that I object, but under threat, direction, or coercion. Again,
Your objection is noted.
right, and under threat and duress and coercion,